It is time and we have a quorum for convening the sixth meeting of the Bills Committee on PHU Bill. Before we start our discussion with the administration, let's take a tally of the progress. We have spent 10 hours to conduct 5 meetings. We have completed scrutiny of some 31 clauses. So we have covered 1/3 of the entire bill. Now for the upcoming arrangement, we have 4 hours more on Friday. So please reserve your time slot for 4 hours of meeting on Monday, just in case. If necessary, we will have another meeting on the 1st of August. The Secretariat will issue the notice about the arrangement to you according to our progress. I will not go over the government officials again. We are very familiar with them. Let's continue. Clause 32, Mr. Chen. Thank you, Chairman. Clause 32 is the supplementary provisions for Section 31. That is, immediately before the start of the countdown period, if there are applications pending which are subsequently rejected, or if the refusal of the PHU recognition application occurs within the period of 30 days ending immediately before the countdown period, and if there is still a tenancy in force, the Secretary may direct termination of these tenancy on a date specified by the Secretary. The notification period of termination will be no less than 30 days, so that the affected tenants can move out. The affected tenants can recover the compensation from the operator according to Part 7 of the bill. Any questions? Clause 32. Any questions about Clause 32? 33, please. Clause 33. Again, these are the supplementary provisions for Section 31 concerning refusal to application for recognition. Now, before the start of the countdown period, the application is still pending. Now, when there is an appeal, if the appeal board decides to deny the application, then the appeal board can specify a date on which the tenancy be terminated. The notification period will be no less than 30 days so that the tenants can move out, and also the tenants can recover the compensation from the operator according to Part 7 of the bill. No question. 34, please. Again, Clause 34, they are the supplementary provisions for Section 31. On basic housing unit recognition application still not settled as at the expiry of the countdown period, there are 4 situations under which we will deem the registration to be in force. 1. If immediately before the expiry of the countdown period, the PHU recognition application is still pending and the grace period registration is still in force for the principal flat of the SDU concerned, then the registration will continue to be in force until the application is settled, even after the expiry of the countdown period. Situation 2. If the PHU recognition application is subsequently refused, and the period within which a notice of appeal may be lodged against the decision of refusal runs past the expiry of the countdown period, then the grace period registration will continue to be in force until settled.
The third scenario is if the recognition application is subsequently refused and the applicant has lodged an appeal. However, the appeal against the decision of refusal is still pending and a grace period registration is still in force, then the registration continues to be enforced until the appeal board's decision on the appeal takes effect. And the fourth scenario is if immediately before the expiry of the countdown period an appeal is still pending and the grace period registration is still in force for the principal flat, and then the registration will continue to be enforced until the appeal board's decision on the appeal takes effect. Any questions for clause 34? 35, yes. Clause 35. Offense of letting subdivided units in registered flats during countdown period. The penalty is aligned with clause 8, letting SDU against the law. On summary conviction, is subject to fine at level 6, i.e. $10,000 and imprisonment for 2 years, and in case it is a continuing offense, to a further fine of $20,000 per day. And if it is on conviction or on indictment, the maximum fine is $300,000 and imprisonment of 3 years. In the case of a continuing offense, a further fine of $20,000 per day will provide a defense for the defendant. Now, if the tenancy has got a pending recognition or the period for making appeal has not yet expired, or if the appeal is pending, or the tenancy was at first not for residential purpose and the person did not know and had no reason to suspect that the SDU was used for habitation, or even though the person had exercised reasonable diligence, he could not have prevented the SDU from being used for habitation. This is consistent with what was in clause 8. So the burden of proof is not on the defendant. So a person is taken to have established a matter that needs to be established for defense if there is sufficient evidence to raise an issue with respect to that matter and the contrary is not proved by the prosecution beyond reasonable doubt. That's clause 35. Any question? Legal advisor has a point. Chairman, clause 35 is in relation to offense of letting SU during countdown period. However, there is some difference with clause 8 because the person who commits the offense is the person who lets the SDU, whereas in clause 8, a person who is entitled to receive rent is also covered. So I'd like to know why is the differential treatment under the two clauses. It's both about letting SDUs. How come there are two different approaches? Thank you. Ms. Wong? Indeed, the two offenses are slightly different because clause 35 covers a very limited period, and that is the 6-month countdown period. We mainly target at the operator of the SDU. The operator must maximize the 6-month countdown period available to make the SDU legitimate. Whereas for clause 8, it is a more general offense. If an SDU is let not in compliance with the requirements of BHU, then the person responsible should also cover those who receive rent from time to time from the tenant. So the notice or the observation from the legal advisor is very valid. Any question? If not, we move on to Part 6, Clause 36. Thank you. Part 6, Ancillary or Incidental Powers. There are 8 clauses from 36 to 43. This part is ancillary or incidental powers to be exercised by the Secretary. We have taken reference from general powers available in other relevant legislation. Now, we cover specified application and also for entry to premises with warrants from the court and under some circumstances requiring the operator to rectify irregularities, and that is issue of a rectification notice. Termination notices and also disclosure of documents and information to other law enforcement agencies. Clause 36, requiring documents. The Secretary, in performing some functions, may, by notice, require a specified person to provide within the time and in the way specified in the notice any document or information that the Secretary reasonably considered necessary for performing the function. And these functions can be for determining a specified application, determining whether to cancel a grace period registration, whether to cancel a BHU recognition, whether to issue a ratification notice, whether to issue a termination notice, and whether the ordinance has been or is being complied with in respect of an SDU. And those specified persons covered can include an operator of the SDU, an owner of the principal of the SDU, an occupier of the principal flat of any of the SDU, an applicant of a specified application, and a specified professional. Mr. Tong Li-jie, just a simple clarification. Failure to provide documents is not a breach of the law. It's just that the relevant application may be refused or cancelled. Is my understanding correct, Ms. Wang? Yes, Mr. Jie's understanding is correct. Any follow-up? No, thank you. Ms. Zhou Fi Chen, a simple question. For specified persons, you've covered an operator of the SDU, whether it is current or a past operator. I'd like to know what is the respective period, because even for a contractual dispute, there is a time bar of 6 years. I'd like to know whether there is any time limit here. It depends on the purpose of collecting or requiring the documents. This is to decide whether an application should be approved or a case or recognition should be cancelled. If we are really talking about owner very long ago, he is not likely to be in possession of information required, so it's unlikely that we will disturb that owner. We may talk about the past owner or the one preceding him. So it depends on the circumstances of the case. Thank you. Any further questions? If not, clause 37. 37 is about requiring reports on being notified of changes in conditions of BHU under Section 27, because changes in the conditions may render a BHU no longer in compliance with the legislation. That may involve removal of some of the facilities in the BHU or removal of the toilet, etc. So report from a specified professional will be required. The professional may, in the report, confirm that even though there are changes in the conditions of the BHU, it is still in compliance with the minimum standards. Mr. Tong Lize. Can the Secretary tell us about the time required to submit the report? There must be sufficient time for a professional to compile the report. Can you tell us what is the time frame you have in mind, Secretary? That is, a specified professional may be entrusted to compile a report. And whether there is a time frame for that, we will not specify a time frame here because conditions of BHUs may differ. It depends on the arrangement between the operator and the professional. And once the audit report is available, the applicant will forward the report to us. When we work out the code of practice, we will set out a time frame. That is, the audit report must not be dated back too long. An audit report dated a year ago may not be acceptable. In the future code of practice, we will provide a time frame that is reasonable. Thank you. No follow-up. Any further questions? No. Clause 38. Thank you. Clause 38. Entering premises with consent. Clause 38 is about the Secretary in performing the following functions, such as determining a specified application, whether to cancel a grace period registration, whether to cancel a BHU recognition, whether to issue a ratification notice, whether to issue a termination notice, and whether this ordinance has been or is being complied with. The Secretary may require an authorized officer to enter inspect any part of the subject flat. And then to take any measurement and to record particulars of the subject flat, take any photograph or make any recording of anything in the subject flat, require any person who is present to provide any document or information, to remove for further information on any document, and to do anything that is reasonably necessary. Thank you. Mr. Vincent Cheng. When we discussed the landlord and tenant consolidation ordinance and the water works ordinance, we received the following opinion, and that is when there is suspicion that there is anything illegal going on in the unit, there can be entry and inspection. So if the Secretary suspects that a certain BHU is illegal, then he can require or ask to enter and inspect the flat. I think Clause 38 should be looked at together with Clause 39. For Clause 38, we need the consent of the occupant first. So if we have granted a recognition or issued a ratification notice, we need to gather information in the BHU. We need the consent of the occupant before entry. But if we suspect that there is anything illegal happening inside the flat, or SU has been illegally let, then we can apply for warrant from a magistrate. No consent from the occupant is required. The threshold for 39 is higher. Under 38, we talk about scenarios where officers have to enter the SDU and will respect the privacy of the occupant, and entry will only take place with the consent of the occupant. And if there is any offense, then we need to apply for a warrant from a magistrate. Mr. Vincent Zhang. So is it like compared with the landlord and tenant ordinance and the waterworks ordinance, powers by the secretary are much higher, because if you cannot gain entry with the consent of the occupant, you can go to the magistrate for a warrant. Yes, the powers are rather extensive, because for the sake of enforcement, we have to ensure that colleagues have the necessary power to take effective enforcement action. Can you tell us who are the authorized officers? Will it be colleagues from the housing department or the fire services department or the buildings department? An authorized officer will mainly be from the housing bureau, which is responsible for enforcing the legislation. It will be the task force of the housing bureau. If we have officers seconded to our bureau from the FSC or BD, they will also be authorized. Mr. Tong Li-jie. You talk about consent from the occupier. So you don't have to notify the owner. And if the owner is aware of this request, does he have the right to not to give consent, or can he specify a date for the entry and inspection to take place? Does the owner have the right? After all, we're talking about the private property rights of a person. Ms. Wong, we will not allow this right to the owner to allow us into the flat. After all, a tenancy is enforced and the occupier has exclusive possession of the flat. And so the owner has to seek the consent of the occupier, even for himself to enter the unit. For instance, we're considering a renewal application of recognition. We have to inspect the circumstances of the unit, and yet we are refused entry by the occupier. The owner has to show us that he has exercised his best effort to persuade the occupier to allow us into the flat so that we can go in and gather evidence. If the owner has exercised due diligence but failed, we will give consideration to this. We will not just cancel his recognition because of that. Chairman, what about in the case of the following? The owner has assisted an authorized officer to enter the unit, but can the owner refuse entry into the unit? And what if he wants to reschedule the inspection? Does the owner have that right? We will deal with applications seriously, and if the owner, after communication with the occupier, is of the view that the date is not a convenient one, and then he wants to reschedule the inspection, that's okay, but we will not empower the owner to allow us into the unit himself.
Chairman, I think the administration should reconsider this point. What is the right of the owners? Well, the administration may have specified persons, for instance, public officers, to enter the flat. Perhaps we should rethink about the provision here. Does the owner really have the right to refuse entry of the officers to his flat? Well, as mentioned before, a tenancy agreement is a private contract. Both parties have certain rights and obligations. Well, is it necessary or desirable for the administration to interfere? I think we have to be very careful. Well, if we want to access or enter a certain flat for the purpose of considering the application for recognition of the flat, and if we can't enter the flat, then we could refuse that application. I think first of all we have to respect the occupier, for instance, the tenant of the flat. They have an exclusive possession of the flat while they are living there. Well, Chairman, does it mean then that the owner could interfere or make certain moves so that the officials could not enter the flat? Yes, well, if necessary, we could evoke our power under Clause 39. Legal advisors, you have an inquiry to make? Thank you, Chairman. Yes, on Clause 38 and the coming Clause 39, both are on entering premises with consent. Well, the authorized person could request for provision of any documents or evidence. But then a person may have the right to refuse providing such a document or information because they have the right to protect their own personal data. And the authorized person could not force the person to provide such information. Well, if that is the case, should we perhaps draw reference to that ordinance? It's about the protection of private information. Yes, the legal advisor has raised this point, and we will consider it. Any further question on Clause 38? If not, let's move on to Clause 39. Thank you, Chairman. Clause 39 is on warrant to enter and search premises. A magistrate may issue a warrant authorizing an authorized officer to enter and search any premises if the magistrate is satisfied by information on oath that A, unless paragraph B applies, there are reasonable grounds to believe that there is or may be on the premises anything that is or contains evidence of an offence under this ordinance, or B, if the officer may enter and inspect the premises under Section 38, the officer's request for such an entry and inspection has been refused, and if there are reasonable grounds to believe that there is or may be anything that contains evidence of an offense. And a warrant issued must specify the premises covered by the warrant, the purpose of the entry and search, the name and capacity of the person authorized, and the date of the issue of the warrant. And usually the warrant is in force for 1 month. And the authorized person could enter the premises with such a warrant at any time specified in the warrant, or if no time is so specified, at any time. And the authorized officer could also stop or require any person found on the premises to state his or her names, correspondence address, and contact telephone number, or produce for inspection the person's proof of identity. All right. Clause 39. Any questions? If not, Clause 40, please. Thank you, Chair. Clause 40 is on rectification notices. Well, even a SDU has got recognition, but within the 5 years of a period for recognition, if there are reasons to believe that the unit does not meet with the minimum standards of living conditions, the Secretary, after considering the evidence or documents provided and after considering the code of practice, the Secretary may issue a rectification notice to the operator. Depending on the level of seriousness of the offense, the Secretary could specify the period in which rectification has to be made. And if no such rectification work is done, the Secretary could terminate the recognition of the unit. And if the Secretary is satisfied that the rectification notice has been complied with, then the Secretary must notify the operator in writing of this fact. Mr. Tony Tse, Chairman, thank you. Well, I think it is reasonable that the Secretary may issue rectification notice, and there is a time limit for works to be done. That is for the operator to ensure that he is in compliance to the notice. But would the owner perhaps make use of this as an excuse to remove the existing tenants from the flat? Ms. Wong? After a rectification notice is issued, we will give the operator a reasonable period of time to carry out modification works. And after the expiry of the date, we will then consider cancelling the relevant recognition. So the tenancy would still be in force. The owner or the operation could, in no circumstances, make use of this rectification notice to evict or remove the tenants. Mr. Tse. No follow-up. Thank you very much. No further questions on Clause 40. Let's move on to Clause 41. Thank you, Chairman. Clause 41 is on termination notices. The Secretary, if he believes that there are incompliance to the recognition, or if there are reasons to believe that the SDU is in violation of the recognition, then the Secretary could issue termination notice, and he must specify in the notice the reason for the termination and the termination date. Well, normally the termination date must not fall within the period of 30 days, beginning immediately after the date of the termination notice. And the notice has to be served to the operator or the owner, and the notice has to be posted on the main door or entrance to the subdivided unit or to the principal flat. And the affected tenant could recover as a civil debt compensation from the operator of the SDU for the termination of the tenancy. Any questions? If not, 42, please. Thank you, Chairman. Clause 42 is on supplementary provisions for termination notices, etc. As we understand that there are different tenancy arrangements in the market, the Secretary or the Board may direct the termination of any domestic tenancy on the date so that the new tenancy ceases to be enforced for all purposes on that date. This is to ensure that the SDU in question will not be sublet again after the termination date. And this is to exercise the power under Section 14(2), 24 bracket 2, 25 subsection 3, Clause 32 subsection 2, Clause 33 subsection 2, or Clause 41 subsection 1. These are the empowering provisions. Any questions? No, let's move on. Clause 43, disclosure of documents or information. The Secretary may disclose any document or information obtained under this ordinance to a specified person if he considers that the disclosure will enable or assist the specified person to perform a function imposed or conferred on the person. The Secretary may also disclose other documents. Well, specified persons including the Court of First Instance or the people from the District Court, the Lands Tribunal, a magistrate, or a public officer acting in the capacity of a public officer. And this is irrelevant to the Landlord and Tenants Ordinance 4A, Fire Safety Ordinance, and 95F, Waterworks Ordinance Cap 102A, Buildings Ordinance Cap 123, and Fire Safety Building Ordinance Cap 572. And also in order to assist other departments to carry out research or prepare statistics, or to use the document or information for other similar purposes, the Secretary may disclose any document or information obtained under this ordinance to these relevant parties. And any document or information disclosed must not be so disclosed in a form that would enable an individual to be identified. Mr. Vincent Chang, Chairman, I agree agree to the arrangements in this provision. What about the SDU Tenancy Control Ordinance? That would be in Part 4A of Cap 7. Mr. Lo Wai Kwok, Dr. Lo Wai Kwok. Thank you, Chairman. Of course, we hope that there should be in separate waters or electricity bill in the BHU, but is it provided in the ordinance? Where could we find the provision? Thank you, Chairman. Basically, we are talking about the document or information related to the BHU. As regards water or electricity meters, we have already specified that in the audit report of the specified professionals, there should be provisions showing that the provision of electricity is in place in the audit report. It should show this part, because this is for recognition of the BHU. Well, if we receive relevant information during our enforcement action, we could provide or disclose this information to the Waters Works Department to carry out follow-up action. Yes, we talked about water meters here, but what about electricity meter? If it is already covered in other parts of the ordinance, or if there are other ordinances that would cover that, of course, I'm happy with that. All right, thank you. Ms. Jovi Chen. Thank you, Chair. We have submitted a letter. That is a letter from DAB. If there are, we'd like to know information about BHU that are resided by elders or children. And here it talks about disclosure of document or information to any to government department. So I'd like to know if that would be the same as the data that we require, that is for minors or elders living in BHU. Thank you, Chair. In clause 43, there are subsections 1 and 2, which is different. In subsection 1, it says that the document or information, if it's disclosed to government department, it would be disclosed if it's considered that it would enable or assist the department or the person to perform a function required by the law. And B is for this information to be disclosed to a government department for carrying out research or prepare statistics. For instance, for the Labor and Welfare Department, if they want data to ensure better deployment of public resources to provide protection or assistance to the underprivileged group, then perhaps we could disclose the information we collected from these BHU to the Labor and Welfare Department for that purpose. In doing registration or recognition, we would require the operator to provide certain information. But of course, we can't force them to provide these information because the owner and the tenants, in signing a tenancy agreement, the tenants have no legal liability to provide information about who is living in the unit or the age and so forth about the people living in that unit to the owner or to the government. So we would just require the owner to provide us with this information on a voluntary basis. For instance, he would fill out a form stating how many people were living in the flat or the age of the tenants and so forth. I have a follow-up question. Yes, I understand that this is not a legal requirement. However, I hope that the administration could explain that this is in good faith, that they would like to collect this information. It's not an infringement of privacy. The administration would just want to make good use of this information so as to have a more focused policy for assisting the poor. Even the education department might need this information. For instance, if tenants have to move out from a certain affected flat, there might be children living in those flats, and the children might have to change schools because of relocation to another district. So I believe that these information collected might be helpful to other government departments. Ms. Wong? Thank you, Chairman. We may not need to make use of the legislation to foster or this. Well, for instance, tenants moving out from a unit, we will have a special working group under the housing department, and with the consent of the affected tenants, we could provide this information to the relevant government departments. For instance, if for the affected tenants, if there are children moving out, they have to study in other schools, we will provide such information to the education department with the consent of the tenant.
Mr. Tony Xie, Chairman, concerning the specified person, these are officers in various departments responsible for law enforcement. So will specified persons also include professionals? Some audit reports compiled by specified professionals may be not up to standard. So professional bodies should be responsible for the upkeeping of the standard. So will the government consider including professionals in the category of specified person? Ms. Wong? I think Mr. Jie's question is about audit reports containing false or inaccurate information. So the housing department will refer these cases to the relevant departments for handling. Since this is in relation to the professional ethic of the professionals, we will refer the cases back to the professional bodies to conduct investigation. Mr. Jie, in other words, the professional bodies will be notified of any problematic audit reports, but they are not defined as specified persons. Thank you. Any more questions? If not, let's move on to Clause 44 under Part 7. Thank you, Chairman. Part 7 is about statutory compensation for termination of tenancies. There are 3 clauses, 44 to 46. They set out the statutory compensation which can be recovered by the tenants upon termination of tenancy. Clause 44 defines the situations where statutory compensation may be available, including Section 14, brackets 5, 24.6 concerning refusal to renewal, 25.6 refusal to recognize a BHU, 31, brackets 4 recognition being terminated as the start of the countdown period, 32, brackets 5 refusal to application for recognition pending as at the start of the countdown period, 33, brackets 5 at the start of the countdown period, appeal refused by the appeal board concerning refusal to recognize a BHU, and 41, brackets 5. The Secretary is satisfied that the BHU has contravened the offences and directs the tenancy be terminated. That's Clause 44. Mr. Vincent Zhang. My question is in relation to 45. Any question concerning 44? If not, let's move on. Thank you, Chairman. Clause 45 is about the statutory compensation for termination of tenancies. It sets out the calculation of the amount of statutory compensation. In short, the compensation is equivalent to 3 times the monthly rent or the remaining rents determined. The remaining rents in the tenancy, whichever is lower. If the number of months covering the remaining period is not an integer, it is to be rounded down to the nearest integer. Mr. Vincent Zhang. Now, if the landlord would like to align the termination of one tenancy agreement with the tenancy agreement with other SDUs, then is the maximum compensation limited to 3 months' rent. Now, for other SDUs, is the practice the same? Ms. Wong. Thank you, Mr. Zhang. Now, the statutory compensation may be invoked in situations mentioned in Clause 44. For example, when the Secretary has cancelled the recognition or registration of the BHU and directs the contracts be terminated, then statutory compensation is available under Part 6. Concerning the scenario Mr. Zhang mentioned, if the landlord would like to align the tenancy period of several SDUs, then the landlord must negotiate the arrangements with the tenants. Then the compensation will be dealt with according to the pre-existing tenancy agreement. So the statutory compensation mentioned under Part 7 are only restricted to Clause 44. Thank you. Dr. Wendy Hung. I would like to clarify that the 2 consecutive years of tenancy in Hong Kong, now it's only during the fixed tenancy period that the remaining rent would be compensated. Now for the flexible tenancy period, only the deposit would be returned. So does that apply to compensation mentioned in Part 7? Ms. Wong? As mentioned in my previous answer, the statutory compensation mentioned in Part 7 is only applicable to scenarios mentioned in Clause 44. If the tenancy agreement is terminated in any of those situations, the tenant is entitled to a statutory compensation under Part 7. Concerning other compensation clauses included in the original tenancy agreements, for example, the compensation during the fixed tenancy period, the tenants can apply for compensation under those existing terms. The compensation mentioned in Part 7 does not exclude the other compensation available. But if it is the compensation for the fixed term tenancy that would be much lower than in the flexible tenancy that would be much lower than the compensation in Part 7. So will the tenant still get the 1 month deposits back on top of the 3 months compensation? As I said, Part 7 doesn't exclude other compensation available in the pre-existing contract. Now, concerning the compensation for termination of tenancy during the flexible tenancy period, it depends on that would not be dealt with by this bill. This bill only deals with cancellation of registration or recognition arising from BHU regime enforcement. If tenancy is terminated under those situations, the tenant is entitled to the statutory compensation under Part 7, which do not exclude the compensation available to the tenant otherwise. Now the court can make a decision on whether the tenant is still entitled to the other compensation after getting the statutory compensation of 3 months under Part 7. Clause 46, please. Thank you. Rights under common law, etc., not affected. Clause 46 sets out that the payment of statutory compensation for the termination of a tenancy in accordance with Part 7 does not affect any rights of the tenant under common law rules or equitable principles to make any further claim against the operator of the SDU concerned. For example, if the tenancy is terminated before the end of the tenancy agreement, before the end of the tenancy period, the tenant can apply for compensation according to the existing terms in the lease. No question. We have now come to Part 8, Clause 47. Thank you, Chairman. Part 8 is about the appeal mechanism. There are altogether 3 divisions and 24 clauses from 47 to 70. It's about what decisions made by the Secretary is subject to appeal, the composition of the appeal board, and also the appeal procedures. In formulating the mechanism, we have made reference to the Hotel and Guest House Ordinance, the bed space ordinance, and also the latest ordinances. Now, Clause 48, Appeal Panel. The Appeal Panel must Clause 47, Interpretation. The Appeal Board must comprise qualifying legal professionals to deal with the legal issues arising from the regime. So in 47, we set out that qualifying legal professional means an individual qualified for appointment as a district judge under Section 5 of the District Court Ordinance, Cap 336. Mr. Lam Chun Sing, sorry, my question is for 48. Any questions about Clause 47? If not, 48, please. Thank you, Chairman. Clause 48 is about the composition and appointments of the appeal panel. I will read out the clauses. Subclause 1. The Chief Executive is to appoint a panel for hearing appeals under this part. The appeal panel is to consist of the following members: at least 2 qualifying legal professionals and at least 1 other individual. The Chief Executive is to appoint one of the members of the appeal panel as chairperson. In appointing the members of the appeal panel, the Chief Executive must ensure that the chairperson is a qualifying legal professional, and at least half of the other members are not public officers. Each member of the panel is to be appointed for a period of not more than 3 years, but is eligible for reappointment. Mr. Lam Chun Sing. Thank you, Chairman. Now about the appeal panel, there will be at least 2 qualifying legal professionals. That's very clear. Concerning the other members, there is no specific requirements about their qualification. So what is the standard here? I understand that the government adopts the principle that the relevant stakeholders should be appointed to relevant boards. For example, in relation to SDU, there will be engineering professionals or district councillors whose constituencies has a lot of SDUs. So will these be spelled out in the bill? Ms. Wong? That is correct. In appointing the appeal members to the appeal panel, there will be individual members who can follow up on each case, including building professionals and fire safety professionals. And also from the community, there will also be community representatives. Mr. Tony Chair. Thank you, Chair. Has the government considered the number of members to be appointed to the panel? How many cases of appeal do you expect? If the membership is too small, then it will take a long time to process the appeal cases. Ms. Wong. Thank you. Our initial thought is 30 to 40 members. We have considered the appeal mechanism under the Buildings Ordinance and other legislation. Now, besides the appeal panel, we will also establish an appeal board in subsequent clauses. So every time when the panel considers a case, there must be at least 3 members, including the chairperson and 2 other members. So the pool will be 30 to 40 large. In the future, we will consider whether we need to expand the pool depending on the number of appeal cases. Now, since the minimum standards on living conditions and other requirements are clear, there is a low possibility that there are a lot of appeal cases, but if necessary, we can appoint more members to the panel. No other questions. Ms. Jovi Chen, please switch on her mic. Am I coming through? Thank you. Sorry, you are speaking too softly. Please speak up. Thank you. Now, Clause 47, it was mentioned that the government has made reference to other ordinance, for example, the Hotel and Guest House Ordinance. But I think the appeal panel is more similar to the Building Ordinance. I have been a member in the appeal panel, but there hasn't been a lot of appeal cases. Ms. Wong? Sorry, maybe I wasn't clear enough. We have made reference to the Building Ordinance, the bed space Ordinance, and also the Hotel and Guest House Ordinance. We have made reference to all those ordinances mechanisms. Now, I think the 30 to 40 large pool of members will get assigned at least a case each in the initial years. Well, I think the fewer cases you have, the better, because it says that there are not a lot of appeal. Sometimes there may be conflicts of interest among members, so maybe there should be more members in the pool, just to be safe. For each appeal panel, the minimum size is 3 members. So the 30 members can serve on the panel on a rotational basis. So like I said, if we received a lot of appeal applications, we can always appoint more members to the panel. I would like the Deputy Secretary to clarify. The chairman of the appeal panel must be a qualifying legal professional, and the other members can either be professionals or community members. So let's say there is an appeal case. There must be a chairman and a member who are both qualifying professionals. Is that the case? Does the chairperson have to be a legal professional? If there are 10 cases simultaneously being heard, then there will have to be at least 10 legal professionals in the panel. So maybe more than half or even 2/3 of the members of the appeal panel must be legal professionals. Yes, Chairman. Among the 3 members, the chairperson must be a legal professional because interpretation of the BHU ordinance is needed. So in the 30 to 40 large pool of members, we will ensure that there is a sufficient number of legal professionals among them. If necessary, we will appoint more, depending on the volume of appeal cases we have received.
Have you considered or assessed the following? In convening appeal boards, how many will be running concurrently? It can be up to 5 or 10, because in addition to the availability of members, you must have sufficient resources in your secretariat to serve the boards. Yes, we have considered the approach in other departments. Within the Housing Bureau, we will have a secretariat to support the appeal panel and appeal board. How many cases will be handled concurrently? Well, there may be such a possibility, but each case is different in terms of complexity. So we're not going to specify how many members to be appointed to a board. But if there are a large number of cases, where we'll adjust the size of an appeal board correspondingly. Any other question? Mr. Judy Chen. Not really a question, but I'd like to share with you my experience in sitting on appeal boards, such as the URA, on buildings and also housing. Many members in such panels are not always active, perhaps because they're all professionals, their schedules are tight. Given that you have so many potential BHUs and yet you've only got 30 to 40 members in the appeal panel, the number is a bit tight. Please note this, Deputy Secretary. Sure. If we don't have further questions, clause 49, please. Thank you. Clause illness of chairperson of appeal panel, etc. If the chairperson of the appeal panel is precluded by illness, incapacity, absence from Hong Kong, or any other cause from exercising the chairperson's functions, the CE may appoint another member of the panel who is a qualifying legal professional to act as chairperson of the panel. Any question? No? Clause 50. Thank you, Chair. Resignation of members of appeal panel. A member of the panel may resign from office by giving written notice of the resignation to the CE. The notice must be signed by the member and will take effect on the date on which the notice is received by the Chief Executive, or if a later date is specified in the notice, the later date. Dr. Low Wai Kwok. On illness of the chairperson of the panel, or in any case when he is precluded from exercising his functions, are we referring to one single meeting or not? Because usually we have a panel and then we will form a board to hear cases. And in each appeal board, there will be a chairman. Are we referring to this appeal board as well? Because if the chairman of an appeal board is for any reason precluded from exercising his function, will it be too onerous if the CE will have to appoint another chairman as a result? I tend to agree with Dr. Low Wai Kwok. There is a chairperson for the appeal panel and also another chairman for an appeal board. I think you should make it clear. Starting from clause 48, we are talking about the appeal panel. That is the large pool with 30 to 40 members. Dr. Low referred to the chairman of the appeal board that will be dealt with in Division 2, starting from clause 54. If the chairperson of an appeal board is for any reason unavailable, we don't have to trouble the CE. Clause 49 deals with the chairperson of the appeal panel with 30 to 40 members. All right, I got it now. That is the same as my understanding. The chairman of the appeal panel and that of the appeal board are two different levels. For the appeal boards, I think more flexibility should be accorded. Perhaps we will find it clearer as we get to that clause. Yes, you're using the appeal panel and appeal board to differentiate between the two. Yes, this may cause some misunderstanding. In drafting the bill, we've taken reference from other pieces of legislation, and similar terms were used in those legislation. Because we haven't got to clause 54 yet, by then we will be clearer. Any problem with clause 50? No, then clause 51. Clause 51, removal of members of appeal panel from office. The chief executive may remove a member of the appeal panel from office if the CE considers that the removal is desirable for the panel to effectively perform its functions. And if a member of the appeal panel is removed from office, the CE must give the member written notice informing the member of the removal. Any question for clause 51? Legal advisor. Thank you, Chairman. This clause is about removal of member from an appeal panel. The clause should include factors to be considered when the CE exercises this function. And should this clause make clear circumstances under which the member will be removed from the appeal panel, for instance, if he has gone bankrupt and he is mentally or physically incapacitated, making it impossible to perform his function? Should we have some clearer provisions in this clause? Deputy Secretary, thank you. We've taken reference from different pieces of legislation in drafting this clause. The legal advisor asked whether a bankruptcy or physical issues or other reasons can lead to the removal from office by the CE. Yes, these are factors we will take into account. However, in drafting this provision, we are of the view that the CE should only remove a member with good reasons. So we have drafted this provision in this way. Any question? No? Clause 52. Clause 52, publication of notice of appointment, etc. in Gazette. The CE must arrange to be published in the Gazette notice of A, any appointment under Section 48B, any resignation under Section 50, and C, any removal under Section 51. Any questions, please? No? We go on to 53. Clause 53, appeals against decisions. Subsection 1. A person aggrieved by any of the following decisions may lodge an appeal against the decision. A decision to refuse a specified application. B, a decision to issue a cancellation notice under Section 14(1) or 25(1). C, a decision to issue a ratification notice under Section 41. D, a decision to direct the termination of a tenancy under Section 14(2), 24(2), 25(3), 32(2), or 41(1). Subsection 2. A person who wishes to appeal against a decision under subsection 1 must lodge a written notice with the chairperson of the appeal panel within 30 days beginning on the date of the decision, setting out the grounds of appeal. Subsection 3, the appeal notice must A, be in the form and be lodged in the way specified by the chairperson of the appeal panel. B, be accompanied by a document containing first, the particulars of the evidence to be adduced by the appellant at the appeal hearing, and also the name of every witness whom the appellant intends to call at the appeal hearing, and C, to be accompanied by a copy of every document the appellant intends to produce at the appeal hearing. Subsection 4. The chairperson of the appeal panel may, in a particular case, extend the periods specified in subsection 2 if the chairperson considers it appropriate to do so. Subsection 5. If the decision appealed against is a decision mentioned in subsection 1, B, C, or D, the decision is to be suspended in its operation from the day on which the appeal notice is lodged until the appeal board's decision on the appeal takes effect. Subsection 6. However, subsection 5 does not apply if A. the Secretary is satisfied that such a suspension would pose an imminent danger or risk to life or property, and B. the notice of the decision appealed against contains a statement to that effect. Any question? No? Then we move on to 54. Thank you, Chairman. Division 2 is about appeal board. As mentioned, the appeal panel is to be appointed by the chief executive, and when there is an appeal, the chairman of the appeal panel will appoint an appeal board from members of the appeal panel to hear the appeal. Clause 54 is about details of the appeal board. Subsection 1. As soon as practicable after a notice of appeal has been lodged under Section 53(2), the chairperson of the appeal panel must appoint from the panel an appeal board to hear the appeal. Subsection 2. The appeal board is to consist of the following members: A. a chairperson, and at least two other members. Subsection 3. In appointing the members of the appeal board, the chairperson of the appeal panel must ensure that A. the chairperson of the board is a qualifying legal professional, and B. at least half of the ordinary members are not public officers. Subsection 4. To avoid doubt, the chairperson of the appeal panel may appoint himself or herself to be the chairperson of the appeal board. Subsection 5. Any public officer appointed to be a member of the appeal board must, in exercising the officer's function as such a member, act only in the personal capacity of the officer and not be subject to any direction to which the officer might otherwise be subject to in the officer's capacity as a public officer. Any question for Clause 54? Legal advisor. Thank you, Chairman. In this division, is it necessary to add provisions in relation to disclosure of interest by board members? Because if a board member is aware of any direct or indirect pecuniary interest or personal interest in a particular case, shouldn't he have the duty to disclose the nature of interest concerned to the board? And once he has made the disclosure, he should stop from being a member of the board. Because in the Hotel and Guest House Accommodation Ordinance, a similar provision on disclosure of interest is present. Thank you. The legal advisor raised this issue. If there is any disclosure of interest required, we have taken reference from different approaches in different pieces of legislation. It can be provided. It can be provided for in the bill, and it can also be done administratively. And we believe for this case the latter is suffice. Any question? No. Clause 55. Clause 55 is illness of members of appeal boards. If the chairperson of an appeal board is precluded by illness, incapacity, absence from Hong Kong, or any other clause from exercising the chairperson's functions, the chairperson of the appeal panel may appoint himself or herself or any other person from the panel who is a qualified legal professional to act as chairman of the board. If a member of the appeal board is precluded by illness or any other reason, the chairperson of the panel may appoint any other person from the panel to act in the member's place. The hearing of a panel may be continued despite any change in the membership of the board under this section. Any questions? If not, Clause 56. Thank you, Chairman. General procedure for hearing. Subject to this division and the regulations made under Section 70, The procedure for convening a hearing of any appeal board and for conducting the hearing is to be decided by the board. A hearing of an appeal board is to be presided over by the chairperson of the board. Any questions? Clause 57. Quorum for hearing. The quorum for hearing of an appeal board is 3 members of the board or 1/2 of the members of the board, whichever is the greater. For determining the quorum, if the number of members of the appeal board is not an even number, the number is to be regarded as having been increased by 1. Questions, please. Clause 58. Voting at hearing. In the hearing of an appeal, every question of law before an appeal board is to be decided by the chairperson of the board, and every other question before the board is to be decided by a majority of votes of the member of the board who are present and entitled to vote. So for the purposes of subsection 1b, each member of the appeal board who is present at the hearing has 1 vote. However, if there is any equality of votes in respect of the question, the chairperson of the appeal board has a casting vote in addition to his or her original vote. Ms. Doreen Kong. The appeal board must have at least 3 members. That means sometimes more than 3 can be appointed. Is there any criteria? Or does the secretary have any idea the kind of cases that require more than 3 members? What are the criteria for making that decision? Ms. Wong. Our appeal panel will only have a size of 30 to 40. So for ordinary appeals, we will follow this formula: 1 chairperson plus 2 members. But for relatively complicated cases where, apart from building safety issues, fire safety, and also other issues of minimum standards are the point of contention, more members may be appointed to the board. In general, we believe the formula of 1 chairperson plus 2 members will be able to handle ordinary appeals. Any other questions? No? Clause 59. Parties to appeal. They are the appellant and the secretary. Any question? Clause 60. Date, time, and place of hearing. The chairperson of an appeal board must fix the date, time, and place for the hearing of the appeal so that the hearing may begin as soon as practicable, and serve on the parties to the appeal a notice of the date, time, and place of the hearing. Any questions? Clause 61. Procedures of appeal board. Subsection 1. An appeal board has the following powers when hearing an appeal. A. Power to take evidence on oath. B. Power to require evidence to be given on oath. C. Power to summon a person to become a witness, to attend the hearing as a witness, to give evidence, and provide any document or information in the person's possession or under the person's control that may be relevant to the hearing. D. Power to examine witnesses. E. Power to require the provision of and to receive and consider any material. F. Power to determine the way in which any material mentioned in paragraph E is received. And then power to afford to a person the expenses that, in the board's opinion, the person has reasonably incurred because of the person's compliance with a summons issued to him. H. Power to make any order that may be necessary for or ancillary to conducting the hearing or carrying out its functions. And I. Power to give any direction to the secretary with respect to the exercise of any of the secretary's functions under this ordinance that relates to the appeal. Subsection 2. With the consent of the parties to the appeal board may hear an appeal on the basis of written submissions only. 3. If it appears to the appeal board that the secretary has reversed the decision appealed against, the board may determine the appeal in favor of the appellant. for a party to the appeal may, subject to any order made by the appeal board, be present at the hearing and may participate in the hearing in person or through a legal representative or with the consent of the board through another person.
就4A
Subsection 5. For the purposes of subsection 4B1, a company is to be regarded as participating in a hearing in person if it participates in it through any of its directors or other officers. Or a partnership is to be regarded as participating in the hearing in person if it participates in it through any of its partners. And any other body, corporate or unincorporated body, is to be regarded as participating in the hearing in person if it participates in it through a person concerned in the management of the body. Subsection 6. The appeal board may make an order as to the payment of the costs and expenses incurred in relation to the hearing, whether by the board, any party to the appeal, or any person attending the hearing as a witness. And subsection 7, any costs and expenses ordered under subsection 6 to be paid are recoverable by the person to which they are payable as a civil debt. Subsection 8, at the hearing of an appeal, the chairperson of the appeal board may administer an oath to any person. All right. Mr. Rincon. Thank you, Chairman. I have a question on subsection 6. It says here that the appeal board may make an order as to the payment of the costs and expenses incurred. Would it be the lawyer's costs or the legal costs? Because the non-government party could appoint lawyers to attend the appeal hearing if it is a complex case, and in case the government loses, then the cost may be substantial. So in subsection 6, does it mean that the appeal board could act as the court to make order regarding the payment of the costs and expenses? Thank you, Chair. In subsection 6, yes, the power described here, or the authority it describes here, is the same as that of the court, because the decision made by the appeal board is similar to the legal decisions made in a court. So for any costs or expenses incurred in relation to the hearing, the appeal board could make an order regarding the payment of them. Ms. Kong? I hope the administration could go back to reconsider this point. The government actually has different appeal boards, and relevant parties could seek assistance from lawyers. So in recent cases, would a very substantial legal cost be awarded? And there is a taxation process involved. So would that also be applicable to the relevant appeal board? I hope the administration could provide us with further information after the meeting in writing. Yes. Thank you. Legal advisor? Chairman, in clause 61, subsection 4B, it says that a party to the appeal may participate in a hearing in person or through a legal representative. Legal representative, does it mean, according to the legal practitioner regulations, this is referred to the solicitors and the barristers? If that is the case, should it be made explicit here? Thank you. The legal advisor has already raised this point in her letter to our department. The term legal representative here is referred to the lawyer registered in the solicitors register and also the barristers. We will give a response to the legal advisor's question in writing after the meeting. Chairman, right. Any question for clause 61? No. Please move on to clause 62. Thank you, Madam Chair. 62, summons. A summons issued to a person under section 61 (1)(c) must be in form specified in the form specified by the chairperson of the appeal panel, be signed by the chairperson, and also specify the requirements that the person must comply with. Any questions for Clause 62? If not, please move on. Clause 63, offenses relating to appeal. A person commits an offense if the person, without reasonable excuse, fails to comply with a requirement imposed on the person under Section 61, subsection 1b or e. A summons issued to the person under Section 61(1)(c) or an order made in respect of the person under Section 61(1)(h), or does any other act that would, if the appeal board concerned had been a court having power to commit for attempt, have been contempt of that court. And the person commits an offense if he, in connection with an appeal, gives evidence that provides document or information that is false or misleading, or he knows or is reckless as to whether the evidence, document, or information is false or misleading in a material particular. And the person who commits an offense under this section is liable on summary conviction to a fine at level 3 and imprisonment for 6 months, or on conviction on indictment to a fine at level 6 and to imprisonment for 2 years. Any questions? If not, please move on. Thank you, Chair. Clause 64, hearing generally public. 64 to 67 are more technical in nature. Clause 64 specify that subject to subsection, it's about hearing generally public. Clause 65 is about prohibition on disclosure of appeal matters. And anyone who commits an offense under the section will be liable. And Clause 66 is about abandonment of appeal. Clause 67 is about failure of appellant to attend hearing. If the appeal board believes that the appellant with reasonable reason is absent from the hearing, then the hearing could be postponed. But then if it is satisfied that the appellant's failure to a hearing was not due to illness or any other reasonable ground, then the hearing should proceed or dismiss the appeal and confirm that the decision appealed against. And an appeal is dismissed, but then they could submit an appeal, and the appeal board could consider the grounds and to see whether a new hearing should be arranged. Mr. Andrew Lam. On Clause 64, it's about hearing generally public. My understanding is that the appeal board has the absolute right to decide whether the hearing should be made public or which part of the hearing should be made public. But bracket 3 or subsection 3 mentions that the appeal board must have regard to the views or private interests of the parties to the appeal, including any claims as to privilege. I'd like to know, first of all, from the administrative point of view, what scenarios do you have in mind that the appeal board must consider those interests of the party, the private interests of the parties? And if the decision of the appeal board is absolute, if he has made a decision that is not satisfied to either of the party, then it seems that the decision is absolute and there's nothing could be done. I'd like to seek clarification on these 2 points first. Ms. Wong, thank you. Clause 64. Well, generally speaking, the hearing should be public because this is for jurisprudence and also equality of the parties concerned. But then if there are information regarding to personal interest or personal privacy, for instance, regarding the condition of the relevant units, or if it involves privacy of the parties concerned, and if these might affect the decision of the appeal, then chairman of the appeal board could consider making that hearing or that part of the hearing private or non-public. Of course, in actual operation, the appeal board would consult with relevant parties before making such a decision. Well, I just now asked about the scenario under which a hearing should not be made public. Well, the Deputy Secretary mentioned about commercial interests or commercial secrets or privacy. Do you have any actual scenario that you think a hearing should not be made public? What sort of reasons would be accepted? Well, I believe that the appeal board, in making such a decision, would consider very carefully. Generally speaking, the appeal board would opt for a public hearing. But then if the appellant, for instance, the owner of the unit, says that he will provide certain evidence that may be sensitive in nature, and if he requests that the appeal board consider turning part of the hearing or the entire hearing private, he could raise such a request. Then it would be up to the appeal board to consider if the reasons are or have ground. Mr. Lam asked me to cite a concrete example. It would be quite difficult because every case would be different, and the sensitive information might be different in nature. So it's difficult to give a specific case as an example. We have to rely on the appeal board for their decision. But the default mode is to make the hearing public. I have a follow-up question, Chair. Going back to the procedures. It says here that it must have regard to the views or private interests of the parties to the appeal. You don't need to issue any particular guidelines to the appeal board in making such decisions, right? Well, we have taken reference from relevant ordinances and legislations, and the arrangements are the same. And in text, English text, the word must have regard is used. No further questions? Let's move on. A legal advisor? Well, Chairman, I'd like to follow up on Clause 65 regarding prohibition on disclosure of appeal matters. It states here that the appeal board may, by order, prohibit or restrict the publication or disclosure by all or any of the persons present at the hearing of an appeal of any evidence given at the hearing or any matter contained in any document or information provided or received in evidence at the hearing. And the appeal board has to inform the relevant parties and also state the reasons why such a decision is made. I understand that relevant or similar arrangements for tourism legislation. Would the administration give us further information about this? Yes, we have drawn reference from the tourism ordinance, and we believe that in the future, when the appeal board decides that certain appeal matters have to be prohibited from disclosure, they would state the reasons behind. And we could handle this through administrative procedures. Any follow-up? No? Let's move on. Thank you, Chair. Next, Clause 68, Decisions of Appeal Board. An appeal board may confirm, vary, or reverse the decision appealed against. And the appeal board must give reasons in writing for its decision. And it should confirm or specify the date on which the decision is to take effect, and the decision is to take effect on a date that falls after the period of 30 days, beginning immediately after the date of the decision. And as most decisions made by appeal board, these decision of the board is final, but the appellant could raise his appeal to the court for judicial review. Well, what about the notices? If the notices are removed, I don't see any penalty set out here. Ms. Wong? Thank you, Chair. Yes, we mentioned about the posting of the notices. Well, indeed, there is no provision about the penalty for removal of the notices. We have taken reference from other relevant legislations, and from our point of view, if the appeal board has made a decision on SDU, the relevant parties, such as the owner or the tenants, should be notified. And we specify here that the notice has to be posted on the main entrance or the door of the unit. Well, for instance, if the decision is about cancellation of registration of the unit, then we will have a specified social work team to see if the existing tenants need any assistance for removal. The first step is to post such a notice so that relevant parties would know ASAP about the decision of the appeal board. And then there will be follow-up actions carried out by our administrative divisions. Chairman, about posting of the notice is a legal requirement. If you make use of other means to notify the tenants, that would be administrative arrangements, right? That would be through administrative arrangements. I assume that, theoretically speaking, the legal requirement should be transparent and it must be complied with. But for the administrative arrangements, it is not mandatory. It could be affected by different factors. Well, I understand that you mentioned there are other legislations also mentioning about the posting of the notices. However, for us, for this present legislation, it might be different, because posting of the notice is the one and only legal requirement or legal channel for the relevant parties to be notified about the notice. There might be reasons, it could be because of different reasons that the notice might be removed. Let's just put aside why the notice is removed. I'd like the administration to perhaps think about adding in a clause to specify the penalty for removal of notices.
Thank you, Chairman. The reason why the notice must be posted on the main door entrance is to notify the tenants of the decision. Now, the cancellation of the regulation means that the SDU cannot be let out anymore. Otherwise, it would be an offense. Now, the subject of the appeal is the operator of the SDU. They must be aware of the decision, and they have a responsibility to discontinue or cease letting out the SDU. So the most important person to be made aware of the decision is the landlord. But we will also post the notice on the main door of the principal flags so that the tenants are aware of the notification too. So if we make removing the post an offense as well, it means that the administration has to inspect the principal flags from time to time to see that whether the notice is still posted on the door. If not, evidence must be gathered to find out who is the culprit. So we don't think it is necessary to criminalize the behavior. Understood. Well, actually, we can make reference to other legislation. When there are obstacles on the street, notices would be affixed onto the objects. So maybe we can make reference to those legislations. Understood. Thank you for explaining your considerations. So the important thing is when a notice is removed, it will still not affect the welfare of the tenants. Mr. Rin Kong. Concerning the decisions made by the appeal board, will the decision be made public? I know there will be a notice posted onto the door, but will the decision be made public on your website for public education's purpose? Second, the decision made by the appeal board can take effect immediately or on a date specified by them. So about the written ruling, the decision, when will the appeal board be required to hand down a written ruling? That is the job of the Secretariat. Sometimes it takes a long time for the Secretariat to complete the written ruling. Ms. Wong? The decision made by the appeal board would be made public. There will be a website for BHU. On the website, there will be information concerning registered or recognized SDUs. If a case is pending appeal, we will make a note that the case is being handled. If there is a decision, for example, if the appeal is granted, then we will make a note that the flag is still a recognized flag. If the recognition is cancelled, the name of the flag will be removed from the list. Second question concerning the written ruling handed down by the appeal board. When will it be available? Now, after the meeting, I will make reference to other departments' practice, and we will make a pledge concerning the period, a reasonable period within which the written judgment would be handed down, because it relates to whether the flag still meets the requirements. So a delay would not be satisfactory. Another matter, the decision made by the appeal board may be subject to judicial review. But unlike other appeal boards, the decision made by this appeal board would affect the welfare of the interest of the landlord and the tenant. It will affect the recognition. So in case of an appeal or a judicial review, what will happen to the recognition? Will the tenancy agreement be required to cease immediately, or can it stay pending the decision of the judicial review? Now, we have thought about that. According to subsection 7, the decision of the appeal board is final. That is, considering the recognition or the registration, that decision is final. Now, of course, the landlord can apply for a judicial review concerning the appeal board's decision. Now, according to my experience, the appeal court would only make a ruling on points of law. If the court rules that the decision made by the appeal board is unlawful, then the case would be handed back to the appeal board for a new hearing. But according to subsection 7, the decision of the appeal board is final. It does not relate to the question of law. One more question. If the appeal board confirms that the recognition should be struck out, then the tenancy agreement would end. Now, the tenant has received a 3 months rent compensation. However, in the judicial review, the appeal board considers that the appeal board has to hear the case again because of problematic legal issues. Then the appeal board make a new ruling that the recognition should stand, but the compensation has already been paid. So what will happen? Ms. Wong, if the decision has changed upon another hearing, then I think the relevant parties can make an application for compensation with the court. That's the usual practice. Please press the button again if you have any other questions, Mr. Ring Kong. Next, Ms. Judy Chan. Thank you, Chairman. Now I'm taking the perspective of a tenant of SDU. The main concern when the bill, behind the bill's introduction, is that we don't want to see any eviction or loss of accommodation by anyone. Now, if the affected tenants have the needs, the housing authority would provide temporary accommodation for the tenants. So the appeal board's decision may affect the welfare of the tenants, despite having a 30-day period to find another accommodation. So I wonder, will the affected tenants be covered by the provision here? Concerning Ms. Chan's question, we now have a Category C tenants under transitional housing as a regular arrangement. For Category C, if SDU tenants are affected by SDU enforcement or decision made by the appeal board, the tenants may apply for transitional housing allocation under Category C, or they may even apply for a transitional housing unit earlier if they are eligible for any categories. So the transitional housing project is available for any tenants. Now, I would like to hear members' views. Now, we only have 69 and 70 left under Division 3. For the sake of completion, we can start from Clause 71 next time, but I may have to extend the meeting for another 15 minutes to complete scrutiny of Clauses 69 and 70. There being no objections, please continue. Thank you. Division 3, Miscellaneous. These are technical clauses. 69, Privileges and Immunities. An appeal board, when hearing an appeal under this part, has the same privileges and immunities as it would have if the appeal were legal proceedings in a court. And also 70, the Secretary is empowered to make regulations for the above appeal process. Any questions? In that case, we have covered the entire part, and we can end the meeting on time if there are no AOB. The seventh meeting will be held at 8:30 a.m. on Friday, 25th of July. There being no AOB, the meeting is adjourned. Thank you.